hearing in the appeals KM Jamaica and Congo against the Secretary of State for the Home Department.
Yes, Mr. Hussain, one of the problems in this case is seeing the wood for the trees. When one looks at the amount of paper, it's surprising if there are any trees left.
Can I just make this point a little more forcefully? In the Court of Appeal, according to the Weekly Law Reports judgment, 27 cases were referred to in the judgment.
Yes.
There were another 16 referred to in argument, which is a total of 43, I think. Yesterday, you managed to direct our attention to 23 cases. In the bundles we've got, there are over 400. And I simply don't know where these have all come from. And if we go on like this in 2 years' time, instead of 40 volumes, we'll be giving us 60. It strikes me as very lazy advocacy, really. What we need is some process of selection so that we're directed to the cases we really need to study. It's quite unacceptable for us to have to wade through volumes of this number. We've now lost touch with the index, because the index which I've got stops at volume 38, and we're beyond that, we're at volume 43 or something like that. Could we at least have an updated index which is manageable and will direct us to the cases we need?
My Lord, yes, of course, your Lordship's comments have been heard very loud and clearly at the bar. We're very sorry, and certainly heed what my Lord says. You do have an alphabetical index which has been prepared in order for ease of reference, which is up to date. We'll certainly get you an updated index.
Well, the volume, this one with the numbers attached to it is also useful, because if you mention a case number, then we can go to it and find it. And it's the best that can be done. But really, in the future, you really do have to control yourself and produce smaller bundles, I would suggest, or at least fewer bundles, so that we have something that's really workable.
My Lord's admonition has been very loudly heard.
Thank you.
My Lord, you should also have a document containing certain errata, headed errata, which is in the bundle. And also, you ought to have a single piece of paper, which is the order in the Nadaraja case. It's not clear from the judgment that it was an action in damages. And that was a question my Lord Brown asked me in February in the SK case. At paragraph 15 of the judgment, there is a reference to damages, but the order makes it very clear that these were damages cases. You see that over the page in the order in Nadaraja, and also at paragraph 2, damages to be assessed, transfer under CPR 54.20, and Amrit Nathan, again, point 2. My Lord,
but was it damages under the Human Rights Act, or was it damages for common law?
It was damages at common law. The arguments will run in parallel. My Lords, my Lady, publication. We deal with this at part 3 of our case, paragraphs 142 to 189, and it is dealt with, the issue is dealt with at section 4 of the Secretary of State's case. Mr. Fordham deals with it at paragraphs 7 to 18.
Which paragraphs of your case?
Our case 142 to 149, Secretary of State, section 4, Mr. Fordham, 7 to 18. I'm
a bit lost, sir.
Sorry, my Lord. Mr. Fordham's case for the intervener.
Sorry, what are we talking about?
The issue of publication.
Oh, I'm sorry.
Of the policy.
Of the policy, yes.
I thought you were talking about anonymity. I'm sorry, I completely misunderstood what you were talking about. Yeah?
No, the second question, whether it is open to the Secretary of State to keep her detention policy secret. The genesis of this issue is rather odd, because before Mr. Justice Davis, the Secretary of State did not dispute that there was a need in law to publish her policies. Instead, she argued that the duty of publication had been discharged. Before the Court of Appeal, the Secretary of State did not appeal Mr. Justice Davis's declaration to that effect, vis-à-vis publication, and this is the first time that it has been argued that the Secretary of State doesn't have a duty to publish her detention policy.
What was the argument that it had been published? How did that run in front of Mr. Justice Davis?
From memory, my Lord, the idea was that announcements in Parliament...
And a good old-fashioned view that announcements in Parliament actually are publication of a policy, is that right?
Yes, the problem was that there was never any disavowal of the published policy. There was...
In other words, it didn't supersede what he said in Parliament. The view was taken didn't supersede the policy which had been published. Is that right?
Yes. The informed and interested member of Parliament isn't simply sitting in Parliament and hearing what he says. He's also uploading and downloading, whatever the term is, the relevant policy, and he sees this is the policy. There was also, I think, reference to the articles in the media as well, if I recall correctly. Press release, I'm sorry. And an interview. There's that sort of material.
May we take it, page 127 of your case, which is in the B annex, B36, and there's a quote at the top of page 127. Yeah?
Yes.
And do we assume the fifth line sentence is meant to read, legal advice is those statements were insufficiently unambiguous?
Unambiguous. I'm sorry, yes. You just check that.
But on the question of publication, I mean,
yes.
Well, you say it wasn't argued in the Court of Appeal, but the Court of Appeal, in fact, decided that you don't have to publish.
Yes.
Yeah.
And that's an important finding. The ramifications are very wide-ranging, and on one view, it would mean that the decision of the Court of Appeal in Nadaraja was wrong, because in Nadaraja, on one view, you didn't so much have an inconsistency of published and unpublished policy. The unpublished policy could be seen to be articulating the published one. They weren't colliding in any way. My Lords, at paragraphs 4.9 onwards of her printed case, the Secretary of State, in what we respectfully submit in a rather unclear fashion, seeks to submit that we are focusing on the wrong target. What she says, paragraph 4.9, if I can just take you to that, please, that the appellants were not detained by the policy, they were detained by decisions to detain them. Well, we accept that. And then this rather odd sentence, the clause which follows is rather odd, which hypothetically, in parentheses, might or might not have been made in accordance with the published policy. Well, is the Secretary of State saying that she doesn't know? If the appellants had been subject to a decision to detain made entirely by reference to in accordance with the published detention policy, the non-publication of the unpublished policy would have been entirely immaterial and irrelevant. We agree with that. But the important word there is if. The unpublished policy then could not have infected the question of whether they should have been detained, even if it was intended to apply to them. And again, we agree with that. I think this is what goes to the question which my Lord Brown asked me yesterday. But it seems as though the Secretary of State is keeping her powder dry on this question in circumstances where, as it were, she has the reliance cards. By reliance, I mean the question of infection, the question of whether or not these policies informed the decision. Were they relied upon?
What about footnote 3? Is that add to our understanding?
Well, the contention is that this is what although the unpublished policy was intended to apply to everybody, it may have been that some people, some caseworkers, weren't in fact applying it. And we accept that the mere existence of the policy, if it's not applied in the individual case, doesn't vitiate. But that's not sort of controversial, it's not interesting, as it were, that's basic. And then the paragraph which follows only makes sense if, in fact, the policies weren't applied to the appellant's cases. And on that issue, the Secretary of State is entirely unclear. It seems as though she doesn't know, one way or the other. We, as I think I've indicated to my lords and my lady, have set out in our case at Annex 1 a compelling account of why we say that the policy was applied. It was the Secretary of State's own evidence that the policies were applied.
Well, the reason why I asked about footnote 3 is that rather suggests the Secretary of State knew perfectly well to whom the unpublished policy was intended to apply and was making sure that they were not misled by being told about the published policy.
Indeed. And we again, it's perhaps best if I hear what Mr. Beloff has to say about that, because with respect, we find the Secretary of State's case on this issue difficult to understand. Hypothetically, might or might not have been made. What happened in these cases? We say they were applied. This also ties in with my Lord, the point that my Lord Collins made yesterday in the context of burden of proof. This is a classic situation where she has the reliance cards. She should know or does know, and we infer, or one infers, that the policy, which was intended to be applied to everyone who was an FNP, was applied. And the reason I'm taking some time on this again is because we've set out in our case how the courts below approached this. It's not clear whether the courts below found in terms whether or not the policy was applied. In WL's case, it looks as though they found that it wasn't applied, but then they moved on to a causation analysis. We say very clearly, we laid out the gauntlet to Mr. Beloff to say, explain to us how it was, if you say that they weren't applied, how that was. My Lords, I'm sorry.
It may exist, I don't think, here, the policy, the unpublished policy, was applied to these two persons. We make no concession in relation to other persons who call FNPs because it will depend on the circumstance of their case, and as your Lordships and my lady have seen from the evidence and the findings of the Court of Appeal, there was an inconsistent practice up to November 2007. That's why one can't make the concession. I don't want my to spend unnecessary time seeking to establish that the unpublished policy was applied to both WL and KM.
And between which dates are we talking now? Up to what date?
In relation to their cases,
Yeah.
from the inception of the unpublished policy, which started as from April 2006.
Until when?
Until September 2008,
I see.
when it became a published policy.
The practice, you say, was inconsistent up until November 2007.
That's what the finding was.
And after that, it became consistent.
After that, it became consistent.
Yes. Thank you.
And is the unpublished policy, I mean, how do you put it in terms of, is it a blanket or is it a presumption?
After November 2007, it was a blanket policy. Up to then, the Court of Appeal have not found it was a blanket policy.
So,
there was the possibility of individuation. But I'm very concerned at the moment, I don't want to tread on that, just to say there isn't a factual issue in relation to these two.
I'm very grateful to my learned friend. Thank you very much. My Lords, we say on the issue of publication that Mr. Justice Davis was entirely correct at paragraph 122 of his judgment. That's at Appendix Part 1A for Volume 2, paragraph 93. Page 93, para 122.
Sorry, can we just find this?
Does my Lord...
I can't find it. 1A.
Yes, if my Lord has full Volume 2, it would also be in there.
So many bloody pages. Core volume part 2, yeah?
It's page 93.
Yeah. Paragraph?
122, my Lord, at the middle of the page. We say he was absolutely right.
We've taken quite a bit of time finding this, but it's set out in paragraph 142 of your case,
Yes, sir.
verbatim.
Yes. I didn't want to necessarily need my Lords to go to it. Sorry.
Was it an issue before the judge? Was this a contentious point?
No.
It was common ground.
It certainly wasn't challenged. And we say... Right. And what we say is that if there is no duty to publish, then the sense of disturbance, quote unquote, which Mr. Justice Mitting felt when the policy was first came to the attention of the courts in April of 2008, would not have made sense. He said, I don't need you to turn this up, but it's at volume 18, 175. This is the Ashuri case, just for your note, volume 18, 175, at paragraph 52. That's the post-judgment exchange between the judge and counsel for the Secretary of State. The judge says, I am rather disturbed to hear this. If there is an unpublished policy dealing with those in immigration detention which affects the timing of their release, then it should be put into the public domain. If you have secret policies, the sense of disturbance would be much reduced, we would say. The Court of Appeal, if I can take you to the Court of Appeal's reasoning, please, and paragraph 70, first of all, which is at...
Well, we have it in the weekly.
So it is in the weekly law reports. For those of you, my lords, my lady, working from the papers, it's at page 32, paragraph 70, for those of you with the weekly law reports. The court concluded that there was no general rule that policy must be published. At 72, across the page, the court said that policies, that the publication of policies was simply a good administrative practice. The unlawfulness, we go back to 71, lay in the fact that there was a departure from the published policy. If I can just ask my lords to go flick back to paragraphs 51 to 52, this just trying to explain the Court of Appeal's reasoning. It's the reason why I'm taking a slightly odd order. At 51 to 52, references to Holgate Mohammed and the reference to D indicated that the Court of Appeal appeared to accept that detention violating public law duties would be unlawful. That's a reference to D, which I've already shown you. Paragraph 52, overlooked relevant features of internal policy. In paragraph 58, across the page, the court indicated, 6 lines up from the end, that we may have arrived at the point where it is possible to extract from the cases a substantive legal rule that a public body must adhere to his published policy unless there is some good reason to do so. It's paragraph 58, 6 lines down from the bottom.
Well, if we're looking at it in the weekly, it doesn't help us to tell where on your page it is.
2195B to C.
B, yes.
I've mislaid my copy of the weekly law reports. At 57, they had said, to state the obvious, policy isn't the same as law. And I want to come back to that because it is that which has generated what we would respectfully submit as much confusion, that idea. And in a nutshell, we say, of course it isn't the same as law as a matter of domestic analysis, but for convention purposes, it often will be law. And the reason for that was encapsulated by my Lord Hope in the Purdy case, where my Lord said that in convention law, in the convention, law is used in a substantive rather than a formal sense. I'll take you to that in due course if that's not clear. Then, my lords, staying with the court,
are you saying that policy is law?
for purposes of the convention, yes.
No difference between statute and policy.
For the purposes of the convention duty of transparent prescription, no, there isn't any difference at all. Of course, policy isn't law in a domestic sense, because there the word law is used in a formal sense. You look at its source, Acts of Parliament, subordinate legislation, orders in council. You look at its status. It's formal. In the convention, you look at matters of substance. What is the instrument doing? If it's regulating the invasion of convention rights, or regulating a power which touches on convention rights, then that is law, yes, absolutely.
Could you remind us then of the passage in Purdy?
Purdy is at tab 20, volume 20, tab 191, paragraph 41. We cite it in our case at 186.
So it's volume 20, tab
199, paragraph 41. This is the suicide case, where my lords reversed the Pretty decision.
Is the point this, Mr. Hussain, that when the convention requires that something be in accordance with the law, the United Kingdom is pretty anxious to argue that the policies regulating the acts of the administration are indeed law for that purpose? Is that the point?
That is the point, my lady, yeah. Yes. And if those policies aren't published, then the United Kingdom will be in breach of the duty of transparent prescription. It's my learned friend Mr. Fordham's phrase in his case. But that confusion between what law means domestically and what law means in the Strasbourg, from the Strasbourg point of view, has generated much confusion and much, we say, difficult consequences, but difficult conclusions, I should say. But also, at 73, just picking up on that point, the Court of Appeal said that the Convention duty to publish only applies to strict law. And at law in the strict sense. And then they followed the holding in the SK case that for present purposes, that means the statute and the Hardiel-Singh principles, but nothing else. And that last point is, we say, very profoundly wrong, with great respect, because, first of all, the Hardiel-Singh principles don't exhaust the requirements of public law. All that Hardiel-Singh was applying Padfield principles of construction, and also Wensbury. You've got to exercise your statutory power reasonably for the purposes in the statute. It wasn't excluding public law duties to follow policy or to take it into account more weakly, as might have been the position then when Hardiel-Singh was decided. We also say that it cannot be right from the perspective of the Convention that you simply have the statute and Hardiel-Singh, because the requirements of detaining for the prescribed purposes, detaining only with due diligence, and not detaining for too long, are all found in 5.1f. They've all been read into Article 5.1f. And we set out that, in our case, at paragraph 154, footnote 54. Now, what that means is that when the Convention in Article 5.1 speaks of a procedure prescribed by law, it's envisaging something more than that. You've already got Hardiel-Singh and the statute. In F, you've got, for a prescribed purpose, you've got due diligence, you've got, can't be over long. So what is it in 5.1 that the Convention is envisaging as applied to our legal system, when it is talking about a procedure prescribed by law, in accordance with the procedure prescribed by law? And we say it's very clear. It's the policies that regulate what otherwise would be an overbroad discretion.
Are we going to be looking at Sardi at some point?
Yes, my lord, yes.
Because my recollection is that under Sardi, Strasbourg said there was no requirement for the detention to be reasonably necessary.
Yes. Yes, but as a matter of substantive law, but it allowed the policy to be changed. But the policy changed, my lord, see, I think the 16th of March 2000, it changed from having a presumption of release to detention in specified cases where you could process a claim very quickly and the person wasn't otherwise unsuitable for detention, so they weren't a torture victim, they weren't a child, and so forth. That's permissible, but that doesn't take the argument anywhere with respect, because it's open, within convention limits, it's open to a state to have different policies. But those policies have to be published. Whatever the discretion is, My Lord, you can't move from the idea that there isn't a strict necessity test in 5.1f to the conclusion that it's open season. And there's no need for... And so there's no need for regulation of the discretion. You've still got to regulate your discretion.
About 30 years ago in Chapman, Strasbourg decided that the Anton Pillar order was compatible with the Convention because the way in which the discretion was exercised could be found from the law reports. Now, are you saying that where the executive has a discretion and that discretion is part of a policy, that there is some analogy between the way that the citizen can find from the law reports the way a discretion is exercised and can find from published executive policy statements the way the executive will exercise its discretion?
Well, it would be very difficult to work out. And let's imagine that the policy isn't published. And we would say that it would not be an answer to an applicant claiming that detention was not in a procedure prescribed by law for the state to say, well, you can trawl through hundreds of law reports and have a guess.
You wouldn't need hundreds. The first time that there was a challenge to the exercise of the minister's discretion in court, there would be a duty to disclose the policy if it had not hitherto been made public.
Yes, well, the problem with that goes back to the point that my Lady Hale made in crisp terms, and it was a problem I was struggling to make, which is that the duty in 5.1 and the duty in 5.4, the obligation in 5.4 to have a remedy, are distinct and cumulative protections. And paragraph 124 of the HL case establishes that. Because the argument in HL was that the detention of a compliant mental patient wasn't arbitrary because you could move the court. And in that case, the court held that substantively it was permissible to detain the individual on the basis of the doctrine of necessity. But there was insufficient procedural protection. There wasn't a requirement of review. It wasn't time limited, and so forth. And therefore, there wasn't a procedure prescribed by law. It was no answer to that complaint that on the substance, it was permissible to detain the individual. And it was no answer, to move to my Lord's point, that you'd be able to move the court and then get the policy published. One has to see, in a context as anxious as this, the position of people who never get to court.
I didn't make my point at all clear. It was meant to be helpful to you, to trying to draw an analogy between judicial discretion, which is definitely a matter of law,
I see.
and executive discretion, which can also be a matter of law. Can also be law in the wider sense.
Yes, I'm so sorry. I was miles away from the question. Yes, indeed. But to answer my Lord Phillips's point, once the policy is disclosed, as it wasn't for a good couple of years, of course, then it would be published. But that wouldn't, strictly we'd say, that's all okay. Would my Lords like the volume references in paragraph footnote 54 to the Grand Chamber decisions in Belmarsh, Sardi and Chahal? I can give you the volumes are, the Belmarsh case is volume 26. You've got the tab 252, paragraph 164. Sardi, again, is it volume 25? You've got the tab 249, paragraph 68 to 74. And Chahal, it's volume 24. You've got the tab 236 at paragraph 113.
Sorry, what's the tab again, please?
I'm sorry, my Lord? Chahal, the tab is 236.
Thank you very much.
113. 236, paragraph 113. Now, in going back to the Court of Appeal's judgment, at paragraph 71, the court referred, this is the middle of the paragraph, the bottom of page 32, you're in the papers. He referred to the decision of Mr. Justice Stanley Burton, as he was, to the effect that consistency with the constitutional imperative that statute law be made known required that the government should not withhold information about its policy relating to the exercise of a power conferred by statute. Now, Sally, I don't want you to take it up, but for your reference, it's 13130, volume 13, tab 130. That concerned a policy regulating the discretion to provide for hard cases support under the Act. So it was a welfare provision to which there was neither, in strict terms, a common law right nor a convention right, although, of course, prolonged destitution could engage rights. But of itself, there was no convention or common law right to such state assistance. Now, he concluded in that case that there was a constitutional imperative that law be made known, of course there is, and that a failure to publish policy in that context was inconsistent with that imperative. We say he was right, but with in the present case, the Court of Appeal rather surprisingly distinguished that decision on the basis that they said it was made in the quite different context, paragraph 72, the quite different context of the Secretary of State's decision to withhold from the individuals concerned an internal policy relating to a statutory scheme designed for their benefit. Well, the context here, we respectfully submit, is far more pressing. This is executive detention. If the premise in Sally is correct, then it must follow that the Court of Appeal are wrong. And the Court of Appeal's conclusion leads to the very odd consequence which Mr. Forden describes at paragraph 15 of his case. That is to say that it is permissible to withhold, impermissible to withhold the policy relating to, say, compensating people who were unlawfully detained. You can have a compensation scheme for those unlawfully detained in the way that you had a scheme for giving state benefit in the Sally case, and that would have to be published, but you didn't have to publish the policy which regulated detention in the first place. That makes no sense at all. And we cite at paragraph 165 of our case, Lord Justice Buxton in the Stafford case, this is the parole case, where the learned judge says that there is a particular obligation on the Secretary of State consistently and transparently to apply whatever policy it is that he's adopted where decisions directly affecting the liberty of the subject are concerned. The Stafford you've got there is at tab 99. The volume is volume 10, page 521G. In our case, at paragraph 177, we also make two final points on this issue as a matter of common law, or domestic law, I should say. First of all, the statute itself envisages a degree of publication because it requires immigration rules to be laid before Parliament, subject to negative resolution procedure. And of course, the House of Lords has held that the rules are no more than statements of administrative policy with legislative imprimatur through the negative resolution procedure, which is an indication, we say, of the clear importance given by Parliament to publication. We deploy that for analogical support. Obviously, it doesn't directly support us.
I'm sorry, I'm lost. I mean, you're not, I take it, suggesting the policy has to appear in the immigration rules, which have to be put before Houses of Parliament.
No, not at all. No, not all of it does. But this is a regime where Parliament has said that for certain classes of people, you need to provide immigration rules that must be put put before Parliament, students, visitors, employers, and so forth. It's an indication that in this field, Parliament envisages publication. I don't need that argument. I don't need
It doesn't
to
even help you at all, because, I mean, Parliament has not said that you've got to indicate how you're going to exercise your Schedule 3, Paragraph 3 power of detention by a reference to rules. I mean, it doesn't envisage rules in relation to that at all. Otherwise, you'd be complaining they're not in the rules.
Well, there is,
as you say, you don't need, but I just, if I
Yeah,
may say so, I think you just carry these arguments just too far.
my Lord, yes. My Lord, can I...
what would be the consequence if the Secretary of State had initially had considered, it would have been probably his powers then, and simply decided on a policy which was Hardiel Singh, but not published it? Would that mean that anybody who was detained was unlawfully detained?
The argument would be that that is overbroad. Hardiel Singh is overbroad as an exercise of discretion. Hardiel Singh sets limits to the legality of detention. It doesn't, and legality is not obviously not the same thing as what the executive would wish to do. It's the outer limits of what they can do. And I've made the point already that the Hardiel Singh limits are already there in 5.1f. They've been read into 5.1f. You need something more than that.
Am I right in thinking at the time of Hardiel Singh there was no published policy at all?
You're right, my Lord.
How far do you take this? I mean, policies are often extremely detailed,
yes,
going into matters really of more of an administrative arrangement than it would be of any interest to somebody affected by the exercise of the policy. I mean, you're not saying, I imagine, that publication requires everything to be published.
No.
But what is the criterion? I mean, how far do you go?
The criteria is that the policy must regulate the invasion of rights under the Convention. It must govern the discretion as far as the individual is concerned. The individual isn't going to be bothered about internal arrangements that have got nothing to do with whether or not, or in which circumstances he's going to be detained.
And it is the point that publication of the policy prevents, or preempts rather, an attack on the grounds that the whole thing is arbitrary.
I love you.
Because one's got some kind of measuring stick against which one can determine whether or how decisions are to be taken.
Indeed.
So a law which on the face of it is overbroad for convention purposes can meet the convention requirements by having something set around it or underneath it, which indicates how it's going to be applied.
Well, indeed, that's exactly our case.
And it's the arbitrary point, really, that it meets.
Anything wrong in the publication of policy which said we shall detain, except in cases which would violate the Hardiel Singh principles?
Well, that's...
In terms of this point, published policy.
You'd have published something, but we respectfully submit that the discretion would still be too broad. It would be overbroad. And the clearest indication of that is the fact that, as I said, I think I've said twice now, I'm sorry if I'm repeating myself, but the Hardiel Singh limits are already inherent in 5.1f.
Overbroad in terms of, for what purpose? Domestically
for the purposes of Article 5, for the purposes of the Convention.
Well, I think you probably say that precisely what the meaning of an application of Hardiel Singh is a matter of some difficulty, as I think this case and some of the arguments you're going to come to demonstrate.
Yes.
So simply to say Hardiel Singh really doesn't tell people who are affected by the policy very much.
Yes, because you'll have children, you'll have people who are mentally unwell, you'll have torture victims, etc., apart from anything else. I don't go so far as to say that where there are unresolved issues in the common law, then that violates the convention standards because, of course, in a system such as ours, that there is room for the law to be clarified in the ordinary process, and that, of course, doesn't violate the convention standard. But it's certainly too broad, we say, to simply say, well, here is the Act, we're going to apply it reasonably, and we're going to apply it for the purpose inherent in the Act and nothing else. That would be far too broad. And if you published a policy to that effect, all you'd be doing is paying, with respect, lip service to the law requirement in the Convention. This hasn't been a live issue before this case. And an example of my Lady Hale's point, we actually have in the papers where the Council of Europe Commissioner for Human Rights, Thomas Hammarberg, criticised the UK's detention policy, the detention powers here as being overbroad, and the government response was to say, here it is, we have published guidance. In fact, they were misleading him because at the time you had the unpublished policy. It was in early 2008. The references are volume 30, I don't need you to take it up at all, but the references are volume 32, tab 333, at paragraphs 51 of the report of Thomas Hammarberg, and the response is set out at page 21 of the report, at paragraph 51 again, where it is said that UK immigration officers are required to comply with published guidance. Well, of course they are, but at that time there was unpublished policy, which was not brought to his attention.
Is that mentioned as a matter of interest in your printed case or not?
No.
Okay.
We refer to it, but not that passage, my lord.
Is it right that the Court of Appeal reached its conclusion by simply adopting the reasoning in SK,
yes,
saying in paragraph 75 that it was binding on it, and that it didn't have any independent reasoning? Or is that wrong?
Well, it certainly had no argument on the point. I'm not sure it would be fair to say to the court that it simply adopted the SK conclusion without any reasoning of its own, because of the passages I've taken my lords to. But we do say that the Court of Appeal were wrong at paragraphs 76 to 78 to criticise the judgment in Nadaraja, because Nadaraja was absolutely correct. It's paragraph 77. They criticised Nadaraja. My lord's, referring to my lord's judgment in that case, where he quoted the Sunday Times, the classic passage from Sunday Times, as indicating that the law must be accessible, and that he moved without further discussion of the principle, but after considering the evidence, to the conclusion that the policy wasn't acceptable. That was an apparent non sequitur. Well, not at all. It's only a non sequitur if you take law in the strict formal sense and you exclude policy from law. That may possibly be found in the earlier passage, paragraph 54. Our domestic law comprehends both the provisions of Schedule 2, that was the Schedule 2 case, and the Secretary of State's published policy, which under principles of public law he is obliged to follow. the court appears to have accepted a starting point without analysis that, in the context of Article 5, published policy was equivalent to law. Unpublished policy, as far as inconsistent with published policy, was unlawful. It's right to say that, as far as my recollection goes, it was not an issue that policy wasn't law for the purposes of the Convention in that case. Given this lack of discussion, we don't regard ourselves as bound by it. We say that the key to this confusion is the confusion between substantive and formal law, encapsulated very pithily, if I may say so, by my Lord Hope in the Purdy case. We join issue with the Secretary of State at 4.9, where she says that requiring policies to be published because they equate it with law is suspect. That's exactly what the Convention says. Requires, as a matter of accessibility and foreseeability, their publication. Accessibility gives you transparency in the system. That is intrinsically good, and foreseeability lets you alter your position, change your position, and that is instrumentally good. And it is also for those reasons, transparency, consistency, and good administration, that policies that have been formulated, or they need to be formulated, need to be published at common law, we say. And so, my Lord, once you have a policy, why not make it public? Why not ensure that individuals affected can enforce and the courts adjudicating can supervise the policy? My learned friends say, for the Secretary of State, at 4.23, that it's inconvenient to do so. They also say that there may be sensitive issues and so forth. Well, if that really is the case, then they can say that to the courts, and on a case-by-case or context-by-context basis indicate that there is indeed a good reason for not publishing. But we say that it must be a presumptive position where you publish. My learned friends also say that there's no clear dividing line between procedure and substance. We say both matter, as the SK case shows. The debate in that case was about whether or not a failure to conduct a review standard with a tort of false imprisonment. It was absolutely common ground that the review itself was of fundamental importance. Query whether it went to the legality of the detention or not, but everyone agreed that it was of fundamental importance. That's a process provision. So substance and procedure, we say, don't go very far. My lords, my lady, that's all I wanted to say about publication.
Just one point. I mean, it's quite interesting to contrast paragraph 4.23 with the passage in Hannenberg, the response to Hannenberg, which you drew our attention to.
Yes.
Because the criticism in Hannenberg was detention is far too unstructured, basically. There's a lack of coherence, and the answer was, well, the government points out that officers with authority to reach these decisions are required to comply with published guidelines.
Indeed.
And it's as short as that.
It's as short as that, indeed. And at the time, again, that was a legal position. There also happened to be unpublished guidelines.
Yes, this is 2008, isn't it?
It's early 2008, yes. It's in between Cullen 1 and Cullen 2.
Yes.
Can I then turn to the third question, the issue of presumption? Is it open to the executive to have a policy presuming in favour of detention under the 71 Act? This is an important issue of principle. It's also live in WL's case because he was detained for the period 9th of September 08 to 22nd of January 09 under the policy which presumed in favour of detention, which you had at volume 2. I'm not going to take it up. Volume 2. I think it was at tab 20. I think I gave it in loose. It wasn't copied properly. We deal with this issue in our case at Part 4, paragraphs 190 to 216. The Secretary of State addresses it at Section 5 of her case. My learned friend Mr. Ravinder Singh QC addresses it in his case for justice, and Mr. Fordham QC addresses it in Bid's case from paragraphs 19 to 24. I need to take, my lords, again, if I may, to the Act, and you have that at 1.1, Volume 1, Tab 1. And we say, if it helps, if I can just give you our two headline points. The first is that the statute, despite appearances, does not enshrine a presumption in favour of detention for any category of detainee. That the statute doesn't do so. And we also say that the Secretary of State's decision-making, when it comes to the executive, it is neutral as to what the Secretary of State is to do. And that is common ground. And we therefore will submit that because the Secretary of State's, the starting point for the Secretary of State's exercise of discretion is open, the common law comes in, and the protection given by the common law to the right to liberty means that a presumptive detention policy is not permissible. The executive have had it right since 1991. They got it wrong when they published a policy presuming in favour of detention in September 2009. And it is interesting that since September 2008, it's interesting that since January 2009, the policy presumes in favour of detention even for FNPs, even since the decision of the Court of Appeal.
In favour of release.
Release. My Lords, the statute then, at Schedule 3, paragraph 2, which is just after page 49 in the clip, paragraph 2.1. This is court recommendation cases. Where a recommendation for deportation made by a court is in force in respect of any person, he shall, unless the court by which the recommendation is made otherwise directs, be detained pending the making of a deportation order in pursuance of the recommendation, unless the Secretary directs him to be released pending further consideration of his case, or he is released on bail. So that's a court procedure. Shall be detained unless directed.
Before the amendments that are in brackets, what would your submission be as to the effect of 2.1?
Our submission would be that it is a holding position. It permits...
Well, does it permit or does it require? Does it permit or does it require?
No. The Secretary of State is required to make a decision on two things in paragraph 2.1. First of all, he is required to make a decision as to whether or not he's going to make a deportation order, because all that the court has done is recommend it. And the second thing he's required to do is to make a decision whether or not to direct the person's release, pre-amendment. And he's got to make that decision both at common law, because the detention must be for the purposes of deportation. And it is the Secretary of State who decides to deport. All that the court does is recommend it. It's the Secretary of State's decision. It is also required by Article 5 because once the individual enters 2.1 detention, he is no longer in 5.1a, he is in 5.1f. His detention isn't pursuant to a criminal sentence. It's pending deportation. So that strongly suggests, we say, that he's got to take a decision on those two matters, and the statute is silent about what he is supposed to take into account. And that is what Mr. Beloff rightly says in his case. And it's at 530 and 531 of his case, 5.30, 5.31 of his case. The detention powers are silent about factors to be taken into account, he says. They are silent as a starting point. And at 5.31, Mr. Beloff says the language of the provisions concerns what should happen if the Secretary doesn't make a decision. These paragraphs do not purport to make any provision as to how the Secretary should make her decision when she does. At 5.32, these provisions do not amount to a legal constraint. In a sense, she has to say that, because if this enshrines a legal constraint of presumptive detention, then for all this time, and indeed now, the policy which presumes in favour of release is unlawful. And it's a point that Mr. Fordham makes. So Mr. Beloff is right to say that when it comes to the executive exercise of discretion, even under 2.1, it's a neutral starting point. And I'll make the submission that if, with a neutral starting point, there is scope for the principle of legality to operate so that presumptive release is the only lawful policy. That is not to say that you can't have a policy saying that if someone is an FMP and you assess them individually and you can see that there are good reasons to detain them, that you can't do so, that the presumption can't be displaced. Of course it can.
Can you have a policy which says FMPs who have committed rape, murder, yes, that there's a presumption that they will be detained if they've committed one of a particularly serious group of cases?
No, your starting point has to be that they should be released. They've served their criminal sentence. That's the territory that we're in.
I mean, I just recollect that there is, under the Bail Act legislation, I mean, there is provision that if you have committed one of those offences and you're accused of another one, then there's a presumption you don't get bail.
My Lord, I may be wrong here, but isn't that the Harrow Crown Court case where where you said that the default position must be one in favour of liberty? So you adjusted the provision. That makes my point for me.
Well, we better remind ourselves of that later. Very well.
Yes.
Yeah.
And then if we include the amendment, it's even clearer. Our position, we say, is even clearer, because the reference to bail is hard to square with an idea that when the tribunal is considering bail questions, it's presuming in favour of detention. And I showed you the bail provisions which apply in appeal cases. Perhaps I should... They wouldn't apply to the reference to bail here. They would apply to the reference to bail in 2.2 and 2.3. Because you can't appeal in the immigration context a recommendation to deport you. You can only appeal it through the criminal court system. But I'll take you to the bail provisions in due course. But they're very illuminating. at the very least, neutralise any suggestion that this statute is enshrining a presumption in favour of detention or permitting the executive to do so. But paragraph 2.2, you've got the situation of the 3.5a deportee, where the initiation of the process is at the executive level. So where notice has been given of a decision to make a deportation order, he may be detained, so permissive, he may be detained under the authority of the Secretary of State pending the making of the order. So that doesn't look very much like presumption at all. In the 2.1 category, of course, you've got a court decision. In 2.3, then where the order is enforced, where an order is enforced, a person may be detained pending his removal or departure from the UK, and if already detained by 1 or 2 above, shall continue to be detained unless released on bail or the Secretary of State directs otherwise. So the same points that we made about 2.1 we make about 3, and perhaps now is a good time.
So I mean, on your construction, what's the difference between the practical effect of 2.1 and, say, 2.2?
Well, they're dealing with different situations. So
well, I understand the different situations, but what is the difference in practice as regards whether the person should be released or not?
Well, you may have a short period. This issue arose in a case called Vote and Data, which I'm going to have to take you to.
Just tell me your answer to that.
I'm sorry, my lord. The answer is that 2.1 would enable a short period between the expiry of a criminal sentence and a decision to detain the individual for purposes of deportation. It's a bridging or holding provision.
You've got to have it because there's necessarily a gap in time when a decision is taken, unless the decision is taken before the end of the
that is
sentence.
what happened after the declaration was made in a case called Sadrati. I just need to take you to 2 cases on this area. It's exactly what happened, where the Secretary of State would take decisions before the expiry of the criminal sentence. It's what happened in WL's case. So his criminal sentence expired on the 23rd of June 2006. The decision to deport him and to detain was made before that.
But why do they not just run 1 and 2 together and say either where the court has done whatever it says there, or where notice has been given? Why not, on your approach, why not run the 2 together?
Because in 2.1 you've got a court that's
yes,
made...
It's finished. Yes, it's finished. But I mean, they've got. I mean, why as a practical matter would the 2 things not be run together? In other words, say that the Secretary of State has to consider straight away on your approach.
Because there's no room for there being detention without the Secretary of State turning his mind to the issue of deportation in a 2.2 case, because the whole thing starts from him. In the 2.2 case, the initiation of the process is by the executive.
Yeah.
So there's no room for the idea that the executive may not have got round to deciding the questions which she has to decide in the 2.2 case. It's a holding provision.
But why not say in 1 where a recommendation has been made, is in force, he may be detained?
I see, my lord. We say there's no difference there.
That's what you say there isn't.
There
That's
isn't
what I
a
was really trying to get.
I'm sorry.
On your approach, there isn't really any substantive difference, is there? Or is that, I'm just trying to understand.
No, there isn't. You've got to... It may even be directed to the governor. It may prevent the governor. It may be dealing with the position where the governor might otherwise be contemplating release. We'd say that's where the import of the paragraph lies. Now, you could have a may there, but the analogy, so it doesn't completely answer my Lord's point, but the analogy would be that, of course, in the prison context, in the Prison Act, the may detain does mean a shall. So, can I take you to the bail provisions, please, which are at page 43. We've had, would my Lords like to see 29.4, which my Lord Brown indicated may have talked about obligation to release. It doesn't, it's not helpful. But we've had copies made if you'd like to see it.
Sorry, I'm sure I don't want it, whatever it is, but I'm lost.
Presumption, presumptively excusable. It was a reference in paragraph 30, subparagraph 2, to notwithstanding paragraph 29, 3 and 4 or 4 above. Did you have page 43, my Lord?
Yeah.
Yes. It's page 43 of the clip is paragraph 30 of Schedule 2 to the Act.
When subparagraph 4 was taken out of paragraph.
Yes.
29.
Oh, I see. Oh, that's right. It was where the obligation came from under 32.
It doesn't come from 4.
It doesn't, okay.
No. But we do say that the implication of the paragraph is that where the grounds for refusing bail are not made out, then the obligation is to release. That's the position as far as the tribunal is concerned.
I'm sorry, so what you're saying, the proper construction application of 30 is that unless you fall into A to E,
Yes.
it's implicit in the provision that you are obliged to release.
Yes.
I see.
Yes. And that's the tribunal, the power of the immigration officer to grant bail is at the facing page 29.2, may release. It doesn't say shall not unless or anything like that. This is bail pending appeal. There's also bail prior to appeal, and that's dealt with at page 27. Again, it's permissive. In permissive terms, may release. And that's at page 27, paragraph 22 towards the top of the page. May be released on bail.
That doesn't seem to be applied to.
It is applied, my Lord. The provisions which apply those provisions are at Schedule 3. It's the page we were looking at first of all, which is page after 49, and the relevant paragraphs are paragraph 2(4)(a) of Schedule 3. That applies.
I see.
That 22 to 25, and then
I get it.
And then the first
Thank you.
bail thing is at first bail provision that we looked at is at Schedule 3, paragraph 3. The key paragraphs that you're looking for are paragraphs 30 and 22 to be applied. They are applied by 4A and 3 of Schedule.
Paragraph 22 and 13, did you say?
Yes, we're looking for, the bail provisions are contained in paragraph 22 of Schedule 2.
Yeah.
That is applied to Schedule 3 by paragraph 2(4)(a). of Schedule 3, and that the other provision which we needed to look at, which has the implicit obligation to release, is paragraph 30 of Schedule 2, and that is applied across to deportation detention, Schedule 3 detention, by Schedule 3, paragraph 3.
But is the same implied obligation under 22?
We say that it's not there in the statute, and that the common law would supply that, yes, implicitly. It's stronger at paragraph 30, clearly it is.
What do you say about the reference to without the consent of the Secretary of State in 31?
Well,
doesn't that provide an additional hurdle?
Yes.
I mean, you're saying that there's implicit in 32 that if those grounds if it doesn't come within A to E, then there's an obligation to release. Where does the Secretary of State's consent come into this?
Well, we'd say that the scope for the Secretary of State to refuse his consent to a decision by an independent tribunal to release someone from executive detention, the scope for that is very narrow indeed. And unsurprisingly, there is a case, I'm told, which says that it can't be unreasonably withheld.
I think you said that yesterday.
I did say that yesterday, yes. But we certainly submit that that doesn't neutralise in some way the obligation to release someone that is implicit in paragraph 32. It's an odd provision. It may be a throwback to a time when decisions of independent courts or tribunals didn't need to be final. My Lords, can I take you then to what we say about the common law? The Secretary of State, in her case, at paragraph 5.20, says that really what is happening in the common law is a legal tool regulating burden of proof, and that is how Lord Atkin's dissent in Liversidge and Anderson is explained at paragraph 5.1 and 5.2.
Paragraph 5.1.
I'm sorry, 5.21 and 5.22.
Yes.
So sorry.
Yes.
We say, and then at 5.27, the principle cited by Lord Atkin was not a general presumption of liberty, but an identification of a presumption rebuttable by the custodian that the deprivation of liberty is unlawful. 5.28, this type of presumption regulating burden of proof. So that's Mr. Beloff's case. All that the common law right to liberty does, it appears, is regulate the burden of proof. We say, with great respect, it does no such thing. If it did, you could not have the idea that neutral provisions of a statute conferring powers of executive detention must be very strictly and narrowly construed. That's got nothing to do about regulating burden of proof. You must have an underlying substantive right which operates to restrict a broad statutory power. It's obviously a principle of legality, but the principle of legality is not based on legal rules about burden of proof, it's based on common law rights. So that doesn't explain that. And secondly, in the tort of false imprisonment itself, it doesn't explain how the law permits the tort to be actionable per se. Without proof of damage. There is an underlying right to liberty which is protected and vindicated by the tort of false imprisonment. It's a substantive right. There is a supreme importance attached to it. In Lord Griffith's words in the Murray case. And therefore we say that if the statute is neutral about what the Secretary of State is supposed to do, then it is quite wrong to marginalise Lord Atkin as it is sought to do. It's anyway wrong, we say. Mr. Buff is in fact just wrong about Lord Atkin, because I'll explain in a moment. It's quite wrong to marginalise Lord Atkin, quite wrong to marginalise the fundamental importance which the law gives to the right to liberty, and to say that it matters not, and the executive can then presume to detain. And the point is, in fact, as encapsulated at 5.26. It's the passage in Liversidge and Anderson at 245. I certainly don't want my laws to put it up. But that was a false imprisonment claim. It was about the right to particulars. And the issue was whether or not the claimant, Liversidge, was entitled to particulars on the traverse of the defendant. And Lord Atkin said, well, yeah, he would get it on that basis, but he gets it on a much broader and much more important basis, which is the general principle that is the pillar of the Constitution. So if you could, my Lord, switch back in the Secretary of State's case to 5.15. We say you would expect the Secretary to exercise her discretion in the way that's set out there, and we would add, according to law, according to the principle of legality, according to the common law right to liberty. And then at paragraph 5.17, where it is said that in the absence of legal constraints, well, let's assume that's right. Let's say that Secretary of State has an open playing field, it's neutral. It would therefore be unsurprising for a detention policy to include guidance that detention would normally follow. Well, we say it would be profoundly surprising to have that. If the statute hasn't expressly said, well, this is what you've got to do. It's got to give you permission to do that, either expressly or by necessary implication, of course. And it would be very unsurprising because it's never happened before. It might be unsurprising to find a provision that those subject to deportation action who have been previously convicted of bail-out offences, who had a record of absconding from bail or immigration controls, and launch to be detained pending deportation. We say no, it's the other way around. And you only need to look at the Act to see it's the other way around. Paragraph 30. And then the sentence in parentheses might be thought surprising if in the circumstances the policy was nevertheless legally required to provide that the individual should only be entitled to remain at liberty. Well, that is to fundamentally misunderstand, we respectfully submit, the common law.
So do you say that it would be surprising to find that there was a policy that those who had absconded from immigration controls were to remain subject to?
Yes, the starting point is liberty.
If that was the policy,
yes,
that would be a surprising policy.
it would be a surprising policy. It's never happened before, and it would be not in harmony with the traditions of the common law, and it would be inconsistent with paragraph 30 of Schedule 2. That's a good reason to detain somebody, but you start with the presumption that you won't. Not for a moment saying that if the case is made out, that it's not permissible to detain them.
But you couldn't you couldn't say to somebody, you shouldn't even say to them, say to the public, well, here's what we would actually do, that if somebody had absconded from immigration controls, avoided immigration controls, what we're going to do is our policy will be that he's going to be detained.
No, the policy ought to be, we apply a policy of presumptive release. If that's displaced in the individual case, then the person's detained.
To do that, but let's say it's a presumption in favour of liberty, but our policy is that if somebody's done that, he'll be detained. That's our policy. That's likely to be, that's what's, should he not be told that's what's going to happen?
It's the displacement which is critical, and the starting point which is critical, the default position which is critical.
Well, I'm not sure I fully understand that either. I mean, take, for example, the bit that's put in the middle about absconding, a record of absconding from bail.
Yes.
Now, a bail judge would certainly take that into account in deciding whether or not bail would be given. And why shouldn't there be a qualification to the policy, the presumption in favour of release, to say, well, if that is the record of this particular individual, the policy will permit you to detain.
Yes, I'm not for a moment saying, my Lord, that it can't be taken into account. Of course it can. But my point is that you start with the presumption of liberty. The policy which I showed you at tab 2, I think it's 21, tab 221, which is the policy that is in existence today, and it's the policy that was amended following Mr. Justice Davis's judgment in January 2009.
Is this the paper you gave us yesterday?
It's the one which follows that. It's tab 21, yes. It's the final tab.
It's the current policy. The current policy.
The current policy,
right,
as in existence since Mr. Justice Davis, not amended back after the Court of Appeal. They could have, on the present state of the law, the Secretary of State could have changed this, but she hasn't. And if you have 55.1.2, cases concerning FNPs are subject to the general policy set out above, including the presumption in favour of temporary admission or release. The starting point remains that the person should be released unless the circumstances of the case require use of detention. The nature of these cases means that special attention must be paid to their individual circumstances. In any case in which the criteria for considering deportation action are met, the risk of reoffending, particular risk of absconding, should be weighed against the presumption in favour of temporary admission or release. Due to the clear imperative to protect the public from a person whose criminal record is sufficiently serious to satisfy the deportation criteria, and so forth. In many cases, this is likely to result in the conclusion that the person should be detained, provided it's lawful. However, any such conclusion can only be reached if the presumption temporary admission or release is displaced after an assessment of the need to detain in the light of the risk of reoffending and or the risk of absconding.
So is the difference between that and what we see in 5.17 the way the first sentence in Secretary of State's 5.17 is expressed? Is that right? I mean, is the difference between what we see in 55.1.2, particularly the last sentence, which reminds you of the presumption, the way in which the first sentence of paragraph 5.17 of the Secretary of State's case is expressed? It's saying detention will normally follow unless it's displaced by particular circumstances. You say it's the wrong way around.
It's the wrong way around. Starting points matter in public law, and they certainly matter in the context of detention.
Sorry, is this document the 55 as amended after Mr. Justice Davis's judgment?
Yes, and as has continued to be enforced. The date of it is August of this year.
But it was actually put into this form in January 09.
Yes, my lord, yes.
And Mr. Justice Davis said, that what did he say about the presumption?
He found for us.
Exactly. So, I mean, this had to accord with his judgment.
I'm not making any point beyond that this exemplifies what we say is a lawful policy, and I'm making a perhaps very weak point, which is that it hasn't been amended back after the decision of the Court of Appeal. It could have been.
I see.
You say that's as far as the policy can go?
Yes. Yes, exactly, my lord. On the 2-1 point, can I just take you very quickly to the case of Sidrati and Voken Data. Sidrati is at 11112, volume 11, tab 112. And this is Mr. Justice Moses, as he then was. Very distinguished representation for both parties. And Mr. Justice Moses says that an issue of some importance has been resolved, arising out of the facilities for ensuring that those in detention pending recommendation for deportation do not remain in detention in circumstances which infringe their rights. It's accepted in this case detention not to release the individual should be quashed. The point has arisen as to whether or not there should be a declaration that the terms of Schedule 3, Para 2 of the Act do not create a presumption in favour of detention upon completion of a sentence of imprisonment. At one stage, it had become apparent officials were taking the view that there was a presumption. I'm not surprised, having regard to the wording. It raised questions as to whether, if there was a presumption, that was compatible with Article 5. Nevertheless, Secretary of State very fairly took legal advice, received simple advice, etc. And then the declaration is made, paragraph 4. Underlying these cases, there did seem to arise a very important point, which I'm happy to say now seems to be resolved. It seems to me the important significance of that point, particularly the importance of compliance with law procedures, which follow, means that the declaration would be made. And then the declaration we don't have here, it's for some reason not in this report. One gets it from the Voken Data case, which is 16161.
It's what?
16, volume 16, tab 161. So these were the case of two claimants whose criminal sentences had ended and they'd continued to be detained under paragraph 2.1 without a decision being taken on their cases. In the first case, a case of vote for 6 months, 6 weeks between November, 8th of November 05 and 22nd of December 2005, and in the second case, a matter of 10 days between, or 8 days, 28th of February to 8th of March. The facts are summarised at paragraphs 2 to 5 in the vote case, judgment of Mr. Justice Smith, in the data case from paragraph 6 to 9, and then at 10, the issue is set out. The only issue was a question of whether the fact that the defendant had not, as was conceded, taken any decision prior to the detention of the two claimants meant that the detention prior to that decision was necessarily unlawful. Paragraph 12, the Secretary of State said there was no need for any decision to be made. The presumption conceded by the defendant in the Sadrati case was said to be an error. And then the declaration that Mr. Justice Moses made is set out at paragraph 13. The order was preceded by a declaration. It is declared that terms of Para 2 of Schedule 3 do not create a presumption in favour of detention upon completion of sentence, and that it's ordered there be no further relief on the Secretary of State stating his intention to operate arrangements in consequence of which a decision whether or not to direct release is made on or before the date on which a person may be detained under paragraph 2.1. That's my Lord Phillips's point. And then the then applicable policy is set out. And Mr. Justice Calvert-Smith summarises the issue at paragraph 20. In summary, the claimant submitted that the first detention wasn't in accordance with the Act, which requires a decision by the Secretary of State, not sufficient to rely on an apparent decision of a prison governor not to release. In reply at 21, the defendant conceded the actual decisions weren't made by the defendant until days in one case, weeks in the other, after actual detention had begun, in breach of policy. Further conceded, this was regrettable, conceded anyway, 2.1 doesn't indeed authorise detention without the need for an immediate decision. Contended that the decision of the prison was a preliminary one that was sufficient. And then my Lord's, Sir John Dyson's judgment in I is set out, Roman 1, so state must intend to deport the person and can only use the power to obtain for that purpose. That's the Hardill-Singh principles distilled by my Lord. Paragraph 22, I find the argument of the claimants compelling. Defendant's argument seems to be on Alice to be an attempt to reintroduce a presumption declared by Mr. Justice Moses to be erroneous. Bottom of the page, the case was simply not on the defendant's radar. And then in discussions with counsel at 23, I raised the practical problems which might be thrown up by a sentence even shorter than the short sentence received by one of the claimants, practicalities of complying with the requirement for a human mind to apply itself. It may very well be that in such a case the court would be prepared to consider the practicalities of such a period, referring back to Mr. Justice Moses' order in Sadrati where the words so far as reasonably practicable appear. But in my judgment, a period of 8 days is too long in the light of a sentence which had been effected by then for well over 2 months. So that's why we say 2.1 is properly to be seen as a holding provision, a bridging provision, in cases where a human mind can't be directed to the fundamentally important question of whether or not to administratively detain someone on expiry of their criminal sentence that has been ordered by a court. My Lords, I'm going to say very quickly that Article 5, we say, for the reasons that we set out in our case, gives you the same answer. The presumption, our printed case, paragraph 197 through to 206. I'm going to be very quick so that Mr. Westgate can commence his submissions. The basic point is that Article 5 is couched in terms of everyone has the right to liberty, that they may be deprived of it on prescribed grounds to be narrowly construed. Yes, Sadi says that you don't need to pass a necessity test, but that does not mean that your starting point isn't that you release someone unless the permitted grounds for detention are shown. We say the Court of Appeal were wrong and far too broad in the way they addressed the point. Those are my submissions. I'm sorry I've gone on for so long. I know Mr. Ruben Singh is going to address you on this issue as well. That's the focus of his submission. But those are my submissions.
I see you deal with Crown Court at Harrow 201, 202.
Yes.
We did accept that you could put an evidential burden on an individual.
Yes. Yes. Thank you very much.
Thank you. Yes, Mr. Wade.
Lord Lady, my submissions deal with the questions of basic damages and exemplary damages. And if the court is content, I'll deal with them in that order. So far as basic damages are concerned, the findings of the Court of Appeal that the appellants would have been detained in any event had they been dealt with under a lawful policy, are of course the subject of appeal in themselves. And this part of my submissions assumes that is incorrect and that the Court of Appeal's findings that the detention was inevitable are sound and stand. And as regards basic damages, the appellant's position is that the court ought to make a substantial award even on that assumption. And the case really is in two parts. The primary case is that full damages should be awarded without regard to whether or not detention would otherwise have happened. And the second part is that, or the secondary position, is that even if detention was inevitable, a substantial award, by which I mean a more than nominal award, should still be made because that is the appropriate way to vindicate the invasion of the appellant's rights that has nonetheless happened, even though detention was inevitable, and that is not properly marked by simply awarding nominal damages.
So it's a matter of marking rather than compensating.
Well, it is compensatory because it's a way of compensating the rights that has been invaded. But in doing so, it fulfills a vindicatory aim. I'll come on to deal with that part of my submission separately. And in particular, I draw on the decision of the House of Lords in Ashley, which Mr. Hussain flagged up, I think, in his submissions yesterday. If I can make a general starting point, which is that the appellant's submissions on this aspect of the case have to be considered together with the submissions of Mr. Hussain yesterday about the nature of the tort being actionable per se, so that it's not necessary to prove damage as an element of the tort. And that, from that it follows, and these are some of the points we've made in our case already, that the scope of the recoverable damages will be determined by the nature of the tort and what it is that the tort seeks to protect against. And the appellant's position is that the correct approach isn't to say that the appellants have suffered no loss in consequence of their false imprisonment. So to argue is to treat false imprisonment in the same way as negligence, where the essence of the tort is harm and a duty not to cause that harm in certain circumstances. False imprisonment is different, as was established in the cases that Mr. Hussain cited yesterday, in that it protects an individual from an unlawful invasion of their right to liberty. And so when a claimant brings a claim for false imprisonment, they do so in respect of the unlawful deprivation of liberty that has occurred, but for the wrong that was done them, the appellant would not have suffered that imprisonment. And that's what their claim seeks to deal with. And damages are awarded, I accept, to put the claimant in the position he or she would have been in if the imprisonment hadn't occurred. But the proper comparison, for the purpose of making that assessment, is between the claimant deprived of his or her liberty, which is the subject matter of the tort, and the claimant who is not deprived of his or her liberty. And that assessment doesn't bring into account the hypothetical actions of a third party, or indeed of the defendant, when those events never actually happened. The appellants say that an analogy can be drawn between this kind of case and other cases of trespassory torts, and in particular, interference with goods, and they rely on Kuwait Airways and Iraq Airways Company. It's volume 12 of the authorities, tab 122, and I'd ask your lordships to look at that. It's tab 122. In that case, 10 aircraft belonging to Kuwait Airways were appropriated by the defendant, Iraq Airways Company, following the invasion of Kuwait in August 1990. 6 of them were later taken to Iran on the orders of the Iraq government, where they were impounded by the authorities there, and only recovered after payment of some $20 million to the Iranian government. But the critical point is that if they hadn't been appropriated by the defendant, that is Iraqi Airways, then there was a finding that they would have been taken by the Iraqi authorities in any event. That finding is at various points, but it is paragraph 76. It's
And which paragraph 76?
Well, yes, my lord, I'm sorry, that it's the decision of, or the judgment of the House of Lords. So
Page 1092.
Yes.
I think.
And one has there, it's the speech of Lord Nichols, that he says elements of both these situations, he's referring there to some of the difficulties that arise in the assessment of damages where there are concurrent wrongdoers. And he says the government of Iraq had already seized KAC's aircraft before IAC wrongfully converted them. Even if the IAC had not converted them in the autumn of 1990, presumably the government of Iraq or some other emanation of the state would have wrongfully retained possession of the aircraft. So in the real world, as it were, Kuwait Airways was always going to be deprived of these 6 aircraft.
By a wrongdoer.
It is, that is absolutely right, that that's a feature of the case.
Well, it's a rather important one, isn't it?
Well, whether it is or isn't, is ultimately a matter of, in effect, legal policy. But what this case establishes is that there's no necessary reason why, as it were, a but-for test should be applied in relation to the scope of damages when somebody has been unlawfully deprived of their liberty, and then the court shouldn't necessarily ask what would have happened but for the deprivation. If I can follow through what the reasoning was of the court, yes, before coming on to deal with, yes, why I say in this case that the fact that the deprivation would have been a lawful exercise should not make any difference. The claim in this case was for payments made in the costs of repair, but also included the costs of financing for another fleet, and those were all consequential damages. A majority of the House of Lords held that liability for conversion was strict, but liability for consequential loss was confined to the types of damage that can be expected to arise from the wrongful conduct. and the plaintiffs there recovered substantial damages. And the reasoning behind that is what one sees in the main speech of Lord Nichols. I've shown you 76, and then at paragraph 82, having set out at paragraph 77 that conversion was the principal means whereby English law protects the ownership of goods. He goes on at 82 to say, having set out principles applicable to successive conversions, that the owner has already lost his goods, but that's really nothing to the point. For the purpose of assessing damages for conversion, by definition, each person wrongfully excludes the owner from possession of his goods. Then over the page of 1094A, nor for a different reason is it anything to the point that absent the defendant's conversion, somebody else or someone else would wrongfully have converted the goods. The likelihood that had the defendant not wronged the plaintiffs, somebody would have done so, is no reason for diminishing the defendant's liability and responsibility for the loss he brought upon the plaintiff. And then he says, where then does this leave the simple but-for test in the case of successive conversion? I suggest that if the test is to be applied at all, the answer lies in keeping in mind, as I've said, that each person in a series of conversions excludes the owner from possession of his goods. The exclusionary threshold is thus to be applied on this footing. Thus, the test calls for consideration of whether the plaintiff would have suffered the loss in question had he retained his goods and not unlawfully deprived of them by the defendant. The test calls for a comparison between the owner's position had he retained the goods and his position having been deprived of his goods by the defendant. Loss which the owner would have suffered even if he'd retained the goods isn't loss caused by the conversion. The defendant's not liable for such loss. Now, of course, what the court is clearly referring to there is a comparison between the owner retaining his goods and the owner not retaining his goods. What's not being contemplated there is as it were, a real-world comparison, because what we know would actually have happened in this case was that the Iraqi authorities would have taken the planes. And so if that's what the court had in mind, then the proposition that would not have suffered the loss had he retained his goods would make no sense. And then in the speech of Lord Hoffman, and this is a passage that's already been set out in the case, so I'll simply refer you to it, paragraph 129 to 130, it's page 1106.
One
129 and 130.
Sorry, yes.
It's really 129, where Lord Hoffman says it's irrelevant that if IAC had not taken possession of the aircraft, someone else would have done so. Secondly, it's irrelevant that having taken possession, IAC would have been prevented from restoring the aircraft, even if it wished to do so, by circumstances beyond its control, the orders of the Iraqi government and their detention in Iran. Liability is strict, thus causal questions are answered by reference to the nature of the liability. My Lord, the policy reasoning behind that, I'm sorry if I take it back to Lord Nichols, it is paragraph 103, page 1098, where he says, and it's the middle of that paragraph, letter B, you deal with goods at the risk of discovering later that unbeknown to you haven't acquired a good title. And that's a strict common law principle. The risk is that should you not have acquired title, you'll be liable to the owner. That seems the preferable approach in the case of a person who can prove he acted in the genuine belief the goods were his, person in possession of goods, and so on. So, my lords, that is a passage which the appellants say can, with minor modification, be applied to the claimants in the present case to in effect establish the general rule. Just as in Kuwait, the claimants' losses had to be assessed on the basis they retained their goods, even though somebody else might have taken them, so here the appellants' losses have to be assessed on the basis they'd have retained their liberty, since that's what they were unlawfully deprived of. Now, my Lord raises the point that in Kuwait Airways this was an unlawful deprivation. But if one analyses the nature of the tort as being one which is designed to compensate for the loss of the liberty that in fact occurred, then a hypothetical outcome is irrelevant to that question, whether it's a lawful hypothetical outcome or an unlawful hypothetical outcome. And some of the difficulties that arise in trying to postulate a lawful hypothetical outcome are ones which underlie some of the difficulties in the respondent's approach in this case in any event, because if an unlawful, or rather if a lawful hypothetical outcome on the part of the defendant will do, what other lawful hypothetical outcomes will be brought into account? Is it possible to say, well, at some point in the 6 months or a year in which you were detained, you might well have committed an offence and been imprisoned for that reason? Is it possible to take into account the actions of completely different third parties? Does one take into account actions which are the result of natural circumstances rather than wrongdoing? And so it's not a straightforward answer to say, well, Kuwait was a tort case, and there's a clear distinction between that kind of case and other cases. That there simply isn't such a clear distinction. And the respondent's proposed solution, as it were, doesn't tackle how one deals with those alternatives, nor indeed does it deal with how one goes about assessing what would have happened. The Court of Appeal in this case suggested that the threshold should be on inevitability. The respondents appear to suggest in their case that it should be balance of probabilities. But if it is balance of probabilities, then that raises its own policy difficulties, because why should somebody whose right has necessarily been invaded lose any compensation simply because there's a 51% chance they would have been detained in some way in any event? And so there are very many difficulties in going down the apparently seductive alternative route of saying, well, if there's a lawful hypothetical detention, then that necessarily reduces damages to zero or to some other much smaller amount.
So do you ignore altogether the fact that in our case the detention could have been, let's assume it was inevitable that the detention would have been effected lawfully if the thing had been done correctly? Do you ignore that completely so that you assess the damages for false imprisonment in this case in precisely the same way as you would if there were no possibility of a lawful detention and it was a classic false imprisonment case?
Well, yes, one does. One has to if one follows through this reasoning. And I don't shrink from that, because the effect or the basis of this part of the case is that one is simply reflecting there that the principle of assessing damages by reference to the scope of the tort. But that there are, I suggest, good policy reasons why that kind of approach should be the right one, given the nature of this context. Here, the executive are given the exceptional powers to detain, and there's every reason why they should assume the risk of their conduct being found to be unlawful. It's, in effect, an application of May's point made yesterday, that if you have powers to detain, then you should take care to exercise them lawfully, and if you don't, then you take the risk of doing so. It's always in the respondents' hands as to whether or not they act lawfully. It's always in their hands as to whether or not they substitute an apparently unlawful decision with a lawful one.
Well, that line of thought suggests, I think I can follow this, that there should be some kind of award, but why should it be the measured by on the same basis as a compensatory award?
Well, Lord, if one is simply not taking account of the hypothetical action, then there's really no basis on which to assess it in any other way. Right. I'll come on to suggest that if as a secondary submission, that a solution very much along the lines of what I think lies behind your Lordship's question, that there may well be a middle ground between a nominal award and a full substantive award. But for present purposes, I'm simply suggesting there are good policy reasons why one should have a full award.
And they are?
Well, it's the need to ensure that the protection of liberty isn't diminished and that the right way to strike the balance is that where the executive has made a wrong decision in relation to detention and erred in law so that the detention is unlawful, then they should be liable for all the consequences of that unlawfulness. And again, that's simply the application of orthodox principles in relation to intentional torts. And it's got particular bite here, where, as I'll suggest when we come to look at the exemplary damages aspect, this was a case where the respondent was repeatedly told that their actions are unlawful, but went on nonetheless. And this is really the counterpart in this case, or in this context, of the kind of policy considerations that one has in Kuwait. My Lord's point could just as easily be applied to the tortfeasor in Kuwait, or the tortfeasor in a conversion case, who has innocently converted goods. They are liable for all the consequences that follow, simply because that's the way the law strikes the balance. And there's no reason why the law should strike a more generous balance towards tortfeasors where liberty is at stake. My Lords, the appellants say that their approach is one which is consistent with the authorities where the point has actually arisen for decision, as opposed to where there has only been a obiter or some cases where the point simply hasn't arisen. And so in Kuchenmeister, which was shown yesterday, the claimant was awarded £150 in 1958. I think the present value is something like £2,560, I'm told, for an overnight detention that could have happened anyway and would have happened lawfully. And in Roberts and Cheshire, you were shown yesterday that damages were awarded in that case on a full basis, although it's right to say that Lord Justice Clark in that case did think that there ought to be some adjustment for the fact that detention would have happened in any event. And it may well be that Roberts should be analysed more along the vindicatory principle that I'm going to come to in a moment.
Kuchenmeister was vindicatory, wasn't it?
Stated.
Said to be vindicatory.
In Kuchenmeister,
yes.
Yes, absolutely, yes. And that's he said it was vindicatory but not vindictive. So it was clear that was the object of what was being done.
Of course, that was before the standard measure of damages for false imprisonment was set out as clearly as it now is.
Well, it was certainly before Thompson,
Yes.
which gathered together all of those cases. But what I would suggest is that Thompson is really dealing with a different kind of interest, because the cases that are concerned in Thompson are all ones where there's no dispute about this issue. They're all about cases where someone has clearly been wrongfully arrested or wrongfully detained in some way. And so what they're about is valuing the liberty interest, as it were.
I was only making the point in connection with your point about what the Kuchenmeister Award actually
No,
in today's terms.
No, I'm not saying that, although it doesn't, it bears quite good comparison, actually, with the Thompson criteria, if one looks at it in that way. Some cases have suggested that a nominal award will be appropriate. In particular, there is the cases of Iqbal referred to in our case, and Murray, to which I think you referred yesterday. But the appellant's position in relation to those two cases is really twofold. Firstly, if one takes them on their own terms, they're dealing with a very different kind of situation, the situation which is dealt with here. Because those cases analyse the right to compensation in a false imprisonment case as compensating the victim for, in effect, the experience of imprisonment that they have suffered as the compensatable harm that the tort is directed towards. And therefore they say, well, if you have in fact not suffered any adverse experience because you've been asleep or because you didn't know what was happening and someone turned the key in the door, then you don't get any compensation in relation to that. The kind of case here is very different, because the appellants were very acutely aware that they were being imprisoned, and so their experience of imprisonment was no different from anybody else's experience of imprisonment who is fully conscious of it. And so those kind of dicta aren't applicable here. I accept that that's not a full explanation of all the dicta, because there is Langley, which does suggest that an imprisonment of which someone was aware on a hypothetical basis could be taken into account. But in Langley, the point wasn't, I think, an issue, and certainly Roberts wasn't cited.
I don't think there was any argument on the point.
Indeed.
I think I just threw this remark out, maybe ill-advisedly, but it wasn't an issue and it wasn't the subject of argument so far as I recall.
That's certainly the understanding that one gets from the report, I think. So, on their own terms, what the appellants say is that those dicta simply don't apply here. But secondly, they suggest that they're unsound because they focus on causation of harm instead of concentrating on the nature of the tort as a violation of the claimant's right. And so even if some causation analysis is required and some element of causation should be taken into account in quantifying damages, they still need to be taken or reconsidered because they fail to take account of the element of vindicating the individual's rights. And it's particularly apt to consider those ones because they would perhaps produce uncomfortable results in cases, for example, where the victim lacks capacity. Where the victim lacks capacity. Because in those cases it would be very difficult to say, well, simply because you lack capacity you should have a nominal award. And it's
that thought had crossed my mind yesterday. Thought the notion of somebody who, just because they lack the capacity to understand that they are being deprived of their liberty, rightly or wrongly, that they should not be entitled to some award that recognises that they have been deprived of their liberty.
And it's that brings me on to the in effect, the secondary position, which is to do with vindication. And this is the alternative approach, that one can recognise that in some circumstances at least, some account needs to be given to the fact that a person would necessarily have lost their liberty in any event, but it doesn't follow then that the choice is between a nominal award and a full award in the same way as somebody who would necessarily have been at liberty during that period.
Isn't the analysis very similar, whether you say you're talking about an invasion of right or deprivation, physical deprivation of liberty? Because if you're talking about invasion of right, there's a difference between an absolute right of freedom and a qualified right, in that if you had not been unlawfully detained, you could have been lawfully detained. So
well, that's so.
You've only got a qualified right to be freed.
Well, except that the consistent approach in relation to the liberty interest, both at common law and on the Convention, is that it is an unqualified right. And there are no degrees of interference with liberty, or no degrees of deprivation of liberty, and there's no sense in which the liability for deprivation of liberty depends on fault or the kind of hypothetical circumstances that your Lordship had in mind. So if one goes down that analysis, then in actual fact liberty should be treated as an unqualified right, where the invasion of it is going to demand an award, whatever the consequences. And what I suggest is that cases like Thompson have established that the proper approach in relation to the compensatory element of damages for loss of liberty. And those are cases where this type of point simply doesn't arise. But if one looks at the kinds of loss that are suffered when someone is deprived of their liberty, there is the loss, as it were, of their actual loss of liberty, what one can perhaps call their liberty interest. And the impact that has is it may well vary from claimant to claimant. And so one has to compare the excessively detained claimant in Evans with the undoubtedly wrongfully declaimed claimant in the case of Lunt, which is referred to in Evans. The reference to that is Evans, is in the Court of Appeal, Volume 10, Tab 102. I don't want to take you to it. There are also consequential losses caused by loss of liberty, like loss of earnings, and those create problems about quantification, but what the exercise is trying to achieve is relatively easy to follow. But there's also the claim that says that compensation called for because the right not to be unlawfully deprived of one's liberty is a value highly regarded in itself. And usually that's not necessary to be expressly identified because the compensatory award will cover that. But it reflects, I suggest, that the common sense approach to Roberts and balances on the one hand the idea that damages shouldn't be so low on the one hand to be nugatory and to make set the right at nothing. And on the other hand, the idea that there's a difference between somebody who's detained in circumstances where they would have lost their liberty in any event. Kuchenmeister, I suggest, shows that is a proper object of a compensatory award for false imprisonment. And it's most recently come to the fore in the decision of the House of Lords in Ashley and Sussex, which is volume 18, tab 174. And in that case, the family of a man who'd been killed by the police sought to bring a claim for, including a claim for battery. The police admitted negligence and offered full compensation on that basis, including aggravated damages. So, on a purely compensatory analysis, there was no further damages that they could reasonably expect to achieve. And the question then was whether the claim should be struck out. The passage that I wish to take you to first is from the speech of Lord Scott at paragraph 22, page 975. And it's really the whole of that paragraph down to letter E on 976, but in particular, just under letter F, the purposes for which damages could have been awarded to the deceased, Mr. Ashley himself, had he not died, are not confined to a compensatory purpose, but include also, in my opinion, a vindicatory purpose, and then he refers to a passage from the speech of my Lord Hope in Chester and Afshar. And then at H, although the principal aim of an award of compensatory damages is to compensate, there's no reason in principle why an award of compensatory damages should not also fulfil a vindicatory purpose. But it's difficult to see how compensatory damages could ever fulfil a vindicatory purpose in the case of an alleged assault where liability was denied and trial never took place. And then this passage from Daniels and Thompson. Mr. Justice Thomas observed that compensation recognises the value attaching to the plaintiff's interest or right which is infringed, but doesn't place a value on the fact that the interest or right ought not to have been infringed at all. And then he went on to refer to vindicatory damages for invasions of constitutional rights in other jurisdictions, and drew an analogy there. And then over the page, in paragraph 23, at letter B, just below Rusbridger, or just after Rusbridger, it says that the Chief Constable of the client is entitled to do to admit liability on the assault and battery claim. That being so, I can see no ground on which it can be said that it would be inappropriate for the claim to proceed for vindicatory purposes. Whether, if the liability is established, the vindication could be marked by an award of vindicatory damages or simply a declaration of liability is, in my opinion, unimportant. And so what Lord Scott is clearly contemplating there is that although there's a vindicatory object to damages, which can be an object in itself, in certain circumstances, it simply won't be necessary to go that far because compensation will have done the work of vindication. If one then goes to the speech of my Lord Roger at paragraph 60, it's the passage at 986, letter B, where talking about, if I go a little bit further up, at the top of that page, where it says, by contrast, battery or trespass to the person's action or without proof that the victim suffered anything other than the infringement of his right to bodily integrity. The law vindicates that right by awarding nominal damages. And then he goes on to say that the 1934 Act, having agreed with Lord Scott, says the 1934 Act claim isn't for nominal damages but compensatory damages. Then it says the award of such damages can indeed serve a vindicatory purpose, especially since there's no longer any right to damages for the lost expectation of life. In the case like the present, it would be artificial to divorce damages for the battery itself from damages for the deceased's pain and suffering. And so what appears to be suggested there is that in an appropriate case, vindicatory damages, or the vindicatory purpose, could be satisfied by a substantial or non-nominal compensation. And then at paragraph 80, in the speech of Lord Carswell, who dissented on the question whether the claim should proceed to trial, said this in its letter B: the only relief which the claimants could ask the court to give them would be a declaration, and for the reasons which I shall give, I consider one should not be made. I'm unable to agree with Lord Scott's view that there would be a suitable case for what he terms vindicatory damages. Then he says this: in my opinion, the only function for such damages of this kind, is where there's no other remedy for which will meet the case, there perhaps being no provable loss, except a nominal award of damages to establish the formal validity of the claim. Then it's a time-honored word, establishing some principle of vindicating wounded feelings or character. So what Lord Carswell appears to contemplate is that there may be circumstances where, if only nominal damages would be awarded, then those would be insufficient to vindicate the right. If that would be the normal consequence simply because no losses have been caused. But in that kind of case, it may well be suitable to award a higher vindicatory award. Lord Neuberger, at paragraph 116, didn't, I think, express a view on the appropriateness of vindicatory damages. He referred to the Commonwealth authorities, but simply observed there that in those cases damages was a live issue, and so it didn't affect the point before the House on that case. The approach in Ashley has been recently followed by, at first instance, by the decision of Mr. Justice Eadie in Moseley and MGN. The reference there is volume 40, tab 407. And the relevant passage is at paragraph 216, which is at pages 732 to 3. And it's about 5 lines down that paragraph. And what the judge says there is...
paragraph?
It's paragraph 216. Right. What the judge says there is it's accepted in recent jurisprudence the legitimate consideration of that of vindication to mark the infringement of the right, and then, having cited Ashley and Chester, says again it should be stressed that this is different from vindication of reputation, long recognised as a proper factor in the award of libel damages. It's simply to mark the fact that either the state or a relevant individual has taken away or undermined the right of another. In this case, taken away a person's dignity and struck at the core of his personality.
Just give me the paragraph numbers again.
It's paragraph 216, volume 40, tab 407.
Yeah.
Then he says it's a relevant factor, but the underlying policy is to ensure that an infringed right is met with an adequate remedy. If other factors mean that significant damage is to be awarded in any event, the element of vindication doesn't need to be reflected in the higher award. And then there's a reference to paragraph 23 of Lord Scott. But then he also says, and this perhaps is instructive as well, if the object is to provide an adequate remedy for the infringement of the right, it wouldn't be served effectively if the court were merely to award nominal damages out of a distaste for what the newspaper reveals. As I've said, that wouldn't be the court's concern. It would demonstrate the judge had been distracted from the main task. The danger would be the more unconventional the taste and the greater the embarrassment caused by the revelation, the less effective would be the vindication, the easier it would be for the media to hound minorities. And that has some resonance, although I accept the context is very different. In this case, the circumstances of these cases are ones which, as the judge below observed, evoke little sympathy, but nonetheless, their rights to liberty are ones that need to be jealously protected and upheld. The claimants, or the appellants say, by an award of vindicatory damages, if nothing else. That concludes what I have to say about the basic award. Now, I now propose to come on to the exemplary damages question. The appellants challenge the Court of Appeal's decision that exemplary damages weren't merited in the circumstances of this case. What they say is that the Court of Appeal's characterisation, paragraph 122 of the judgment, fails to grapple with the true picture. Properly understood, the material before the Court of Appeal demonstrated a sustained pattern of highly culpable conduct, meriting condemnation in exemplary damages, and that wouldn't be adequately marked by other remedies. What I propose to do, when I take the Court through the various factors that I say lead to that conclusion, is to take as my starting point for the various heads on which I'm going to gather the material on this, the factors set out in the new submissions that were put before the Court, and which the Court will find at tab 1 of Appendix 5. And I'm really introducing this appendix as well at this point because there are a number of documents that I want to take you to in it. And I'm simply drawing attention to it now to save the Court taking a note.
Did you say tab 1?
It's page 3026, so it's the one before the tab, really.
Oh, right. Yeah.
The point is, as one would expect, there are
That should be good.
if it's going to be any help, what I'm going to be doing for the rest of my submissions will be cross-referring, I hope not too much, between the Core Volume 1, which will have the case, and I'm going to take as much as I can from the case rather than going to primary documents, Appendices 2A and B, and Appendix 5. And I think that should be it.
And what was the page number?
The page in Appendix 5 is 3026.
3026.
Rather than read them out, those are the headings that I shall be going through. The point I should make in relation to point 1, that the respondent operated a hidden blanket policy.
I'm sorry, 3026 starts...
3026, it's paragraph 14, where it says the appellants respectively submit.
And these are heads 1 to 5 in that paragraph?
That's right.
Is there any one or more of these 5s which you say it is essential for you to make good? Or
well, the difficulty is that, as one would expect, that the overall question is one of outrageousness or unacceptable conduct that needs to be marked by an award, and so on. There are a variety of what, in a slightly different context, I think Lord Diplock described as dyslogistic epithets.
Yes.
But
well, in particular, I had in mind, imagine that you didn't make good 5, would you still be saying it was a case for
indeed,
exemplary damage?
Yes, and indeed, one of these, that there are a few issues between the parties on the principles of exemplary damages, but one of the issues is whether the conduct of the proceedings is relevant at all. It's certainly an important part of the appellant's case that the courts were misled, for obvious reasons. But it's not essential because there was a serious constitutional issue before then, which was the operation of a policy in secret, the appellants would say, at the behest of the actual or certainly understood instructions of ministers. And that, the appellants say, is grossly disruptive of the proper relationship between ministers and their departments, and in effect, the inhibition on officials of being able to bring to ministers' attention the illegality of what they were doing. And that is, in one sense, a unifying theme.
Can you help me as to what a civil servant should do if instructed by a minister to do something which the civil servant believes to be unlawful?
Well, it's something which is dealt with in both the civil service and ministerial codes, which are intended to lay down guidelines which can really assist both parties, because obviously a civil servant in that situation is in an impossible position in human terms, because what are they to do, as with anybody else and their employer? But the ministerial codes, it might help to look at them. They're at tabs 378 and 379, volume 37. And the first one is the Civil Service Code, which sets out civil service values.
Tab
378. And
Sorry,
378.
8, thank you.
And the key points, I think, for present purposes, are paragraph 1. It explains the accountability of civil servants and ministers in turn being accountable to Parliament. Then at paragraph 5, under integrity, the obligation to act in a way that's professional and deserves and retains the confidence of all those within whom you have dealings. And then at 9 and 10...
comply with the law.
Comply with the law.
Yes.
That's one. We're dealing here with a situation where there seems to be a conflict.
No, exactly. And then linking with that, at 9 and 10, you must provide information and advice, including advice to ministers, on the basis of the evidence and accurately present the options and facts. And then under 10, you must not ignore inconvenient facts or relevant considerations when providing advice or making decisions. It does then say, frustrate the implementation of policies once decisions are taken by declining to take or abstaining from action which flows from those decisions. But that, of course, must mean lawful decisions and lawful policies. And I think I probably don't need to show you anything else in this code.
What about paragraph 13? Serve the government and so on.
Well, absolutely right. And no civil servant can either decline to follow instructions or to offer biased advice on the basis that they disagree with the proposals that are being put forward. But that's a very different issue to the one that one has here. Because what happened here was that the very clear view that had been formed internally about the unlawfulness of the policy simply wasn't escalated and wasn't taken up to ministers. On the material we have, we don't know exactly what happened.
For the purposes of this argument, do we assume that the ministers did or did not know or think that the policy was unlawful?
Well, the difficulty is that we don't know exactly what the ministers do know or what the ministers were told. There are certainly indications in a memo from Liam Byrne that he had. He was very clearly aware that there was a legal difficulty.
Who was aware?
The minister, Liam Byrne.
Right.
It's referred to in the case, and I'll take you to it. But certainly the language that is being used in their communications tends to suggest that they were aware of the difficulty. But whether they were or weren't, it's the responsibility of ministers to manage their departments in such a way that civil servants are not inhibited and do feel able to bring difficulties to their attention. Because otherwise, there's a risk that civil servants, either innocently or through the very human pressures that my Lord President has referred to, find themselves being made the instruments of an unlawful policy. And that's what the appellants say happened here.
Yes, and just looking at 16, if you have a concern,
yes, that's the...
you talk to a line manager,
yes,
which is what one would really expect. Ultimately, one would expect any civil servant who believed he was being instructed to do something that was unlawful to place that fact on record.
Well, indeed, what one has when one looks at the material is that, and the source here is in large part the interviews, but also the memos that went to and from officials at the time. Certainly at the early stages of the blanket process, the chief executive was privy to meetings with caseworkers who were explicitly expressing concerns about the unlawfulness of the policy. But again, nothing seems to have been done.
Paragraphs 35 and 36 of Mr. Justice Davis touch on things, but the judge concluded that it was very difficult to work out how high it had gone.
Well, absolutely. And the appellant's case is that there was only a partial picture before Mr. Justice Davis. In fact, the picture is still not fully clear because there are critical documents that are missing.
We ought to adjourn until 2 o'clock.
Yes, before we do, if I simply mention the ministerial code, which is the next document, which has includes, again, as one would expect, a duty to comply with the law, 1.2.
2 o'clock.